So you're in a Chapter 13 case, and your attorney's telling you there are some claims that came in that are questionable and we have to do something about it. What do you do? Hi, my name is Scott Goldstein. I am a bankruptcy attorney. I practice in New York and New Jersey, and I help people with financial problems get a fresh start. So today we're going to talk about claims in Chapter 13. In a previous post, I did talk about claims in Chapter 7, and the short version of that is unless there's going to be money left over, you really don't have a whole lot to say. But in Chapter 13 you do. Why? Because Chapter 13 claims are important to determining what you have to pay in your case. And there's three kinds of claims that you need to concern yourself with. The first one are what are called secured claims, and these are claims that have property attached to that claim. For instance, your mortgage, your car loan, the furniture loan that you took out from Raymore and Flanagan. These are all secured claims, and if you are behind on those claims, you need to catch up, unless you're going to strip away the security interest, or you need to pay it outside your plan, or you need to surrender that property. So you have a couple of different things you need to do, but if that number on the, let's say the arrearage, meaning that you haven't paid your mortgage, let's say in 8 months or 9 months, the amount you owe is something you may need to review and determine whether or not that amount is accurate. Now, the next one you have is priority claims, and priority claims are claims for specific kinds of debts that are owed by a Chapter 13 debtor that have special attention given to them under the bankruptcy code. Those claims would be tax claims, for the most part, alimony, and child support. Those are the two biggies that we see in my cases. Now, in terms of tax claims, if you have not filed, you're going to get what's called an estimated claim, and that claim needs to be addressed either by filing your taxes or filing an objection to that claim that says, I don't owe this money because, for instance, I have not filed because I don't have to file, because I am retired and I don't make enough money, or something of that nature. Or you file paperwork with the court to show that, yes, you do have a fixed amount due and that estimate is not accurate and you need to finalize it. Or you would file an objection to say that the money they say you owe is wrong because, let's say they say you owe money for living in a state in certain months and years and you live somewhere else. Alimony and child support, again, you need to calculate that claim and object appropriately, because very often that's going to be filed by your former partner who may not have the best records. It's something you need to look at. Now, when it comes to unsecured claims, it only really becomes important if there is a 100% plan, meaning you're in this bankruptcy because you've got to pay 100% back of what you owe, but you can't do it in the ordinary course for whatever reason. If you're in a 100% plan, then you need to review all of the claims carefully, or rather your attorney does, and you need to see what's accurate, what's real, what's not. Because in 100%, every dollar that is claimed, you're paying out. So your interest is in reducing that. Now, if you're in what's called a pro rata plan, which means that every dollar gets divvied up among your creditors, honestly, it does not pay to have your attorney challenge unsecured general claims, because it really doesn't make a matter. It doesn't make a difference in the matter. And what I would say is that, yes, the principal thing may be important to you, but do you really want to pay your attorney at X number of dollars an hour to challenge the $5,000 claim of a credit card that you don't quite remember? Or who cares, because they're not going to get claims unless they've already been notified in the case. So my suggestion on cases where you're not paying 100%, don't bother. It's just not worth the aggravation. Only deal with it if it's a 100% plan, because then it really makes a difference in the amount of your payment. I hope this is helpful to you. If you have questions about bankruptcy, please review my blog. Please check out my website or our YouTube channel. We will be posting more information, and if you really have questions that need a consultation, contact me. I'm happy to talk. Again, my name is Scott Goldstein, and I look forward to hearing from you.